welcome to Legal Action. I am attorney Susan O'Neill Alvarado, and I'm here today with 3 lawyers from the DuPage County Bar Association to talk to everybody out there about issues related to home ownership, leasing, and other tenant or neighbor-related issues. So I'd like to start out today by introducing to you our current panel. John, may we start with you? Can you please tell everybody your name and where you work and what area of law you concentrate in?
Sure, absolutely. My name's John Polinsky. I'm a partner in the Wheaton Law Firm of Gerard, Kleine, and Butkus. I'm a proud graduate of North Central College right here in Naperville, and I've been on the faculty there since 1987. I mostly represent business people or people in their interactions with business, both from a transactional side and in litigation. Very good. Chuck?
Hi, my name is Charles Jakes. I have my own law firm, the Law Offices of Charles Thomas Jakes, and I specialize in personal injury law, damages for people who have been injured in accidents.
And if somebody needed to find you, Chuck, where might they look for you? Where are your offices
My
located?
office is located in Oak Brook Terrace.
Very good.
We've been out there for 10 years.
Great, great. And Eric?
Yes, my name is Eric Miles. I'm a partner at Fawcett Miles PC. My practice concentrates in corporate law, representing small business owners with their transactions and other matters, and also real estate transactions, including landlord-tenant. We represent plaintiffs and defendants in Cook County, DuPage County, and Will County, in our office in Carroll Street.
Very good, very good. Thanks to all of you, and thank you for being here with us today.
And I guess I should add one thing real quick.
What's that, Chuck?
Plaintiff's personal injury law.
Plaintiff's personal injury, yes. Let's be specific.
Absolutely.
I agree, I agree. Well, we're here today to discuss a very important issue that's important to all of us. Few of us are without neighbors. Few of us are without landlords or tenants, whether it's in our personal lives, in our homes, or in our businesses. So what I'd like to do today is to really talk about those issues surrounding not only home ownership, but also liability that's related to home ownership and the difference between leasing and ownership. So I thought what we might start out with, John, if I could throw this to you, is the difference between, tell us the difference between a condo and a private dwelling. By that I mean a house.
Certainly. Most people think, Susan, when they own their own home, they think they own the dirt, and they own the building and everything that goes with it. Mm-hmm. And that would be true in traditional home ownership. Condominiums, however, you own space. You own what's in between the walls in the building that everybody else in the association owns together. They distinguish between what are called common elements and non-common elements. Mm-hmm.
And that's different and distinct then from a house, because when you own a house, you do own the dirt, don't you?
Yes.
As opposed to a condominium where you own this space in conjunction with others, certain areas of that space, and as you call it, is common areas, did you say?
Common areas and common elements. And you have a right to use the common elements, whether it's the parking or the the recreational facilities or whatever.
Chuck, one thing that comes to my mind is if a person, is there any different liability for a condominium owner as opposed to somebody that owns a house?
Yes, essentially, where you see condominiums being brought into lawsuits and as slip and falls, let's say in a common area on the roadway, on sidewalks in the condominium. In and around the condominiums. And so when a suit is brought, when somebody hurts themselves on a condominium, on the grounds of a condominium, what happens, if that eventually goes to lawsuit, the condominium association is brought in as a defendant, as is the management company, for failure, let's say, to correct a defect, for failure to properly salt or do snow removal in accordance with the contracts and that. So the condominium association represents the people usually in lawsuits.
I see. So
and that's different than a homeowner.
Because the homeowner would be sued individually, is that correct?
That's correct.
Okay. And Eric, associations, condominium associations, are they always comprised of homeowners or condominium owners?
Well, that's a good question. Typically, the association membership will be comprised of those owners of the condo association. They go by a process of electing the directors of the association. But the members of the condominium association will be those owners in that development.
That's an interesting topic, John. I actually had a client ask me once what her liability would be if she were to accept an appointment to the board of a condominium association. I know it's a broad question, but John, do you have any thoughts on that?
Absolutely. Whether it's an association, which is usually a not-for-profit corporation, or a for-profit corporation, the duty of a director is to not be negligent, and to be careful when you're doing your job, and to be honest in your accounting. Typically, if you exercise what they call the business judgment rule, that is to say, diligently try to do your job, you're not responsible for things going awry. Also, most associations, and I advise my private corporations as well, obtain officer errors and omissions insurance coverage for those people to encourage them to be able to do it. And most corporation bylaws or bylaws of condo associations allow the association to defend and what's called indemnify, pay if there's some sort of a loss that gets tagged to the officer.
Right.
Well, Chuck, what about individual liability for these directors or the board members if they are condo owners?
Well, as John just said, the only time liability is really going to attach to an individual is if he acts outside the charter of whatever the organization is or the association is that he's on. I mean, obviously, fraud, all sorts of, there's different, but it would have to be something that would not go along with the ordinary course of the condo's business, okay? Contracts, things like that, okay. Slip and falls, whatever on the property.
Right.
You know, there's a whole host of potential liability issues, but the individual would be protected by the condo association. That wouldn't be a worry unless you really operated outside the association, and I'm talking about things that more border on criminal.
You know, you mentioned fraud. That's a good example. For those of us who are listening who might not be lawyers, give us some other examples. Eric, can you think of anywhere where a condo owner might be personally sued or personally responsible for his or her actions while serving on the board?
Sure. Well, we're talking about outside the scope of their normal business practice. So, for example, if a president of a board was mismanaging funds or personally took it upon themselves to undertake some act that is
completely
abnormal,
outside the
completely
scope.
outside the scope
Right.
of normal, acceptable conduct, that
Right.
might be something that where, you know, Chuck would look at that and say there may be an issue here. But you're talking about intentional conduct,
Right.
outrageous conduct, things that the folks at home would probably recognize as you know,
as being outside the scope entirely.
and unreasonable.
Very
Well,
good.
what people have to worry about.
Chuck,
Sure.
I want you to hold that thought.
Sure.
We're going to take a quick break, and we'll be right back with more legal action. This is an important topic. I do want to follow up, Chuck, so hold that thought. We'll be right back with more legal action.
Today is Saturday.
60 minutes of physical activity a day and eating well can help get your child healthy. Get ideas. Get involved. Get going at letsmove.gov. That's letsmove.gov.
Hello, everybody, and welcome back to Legal Action. I'm attorney Susan O'Neill Alvarado, and we're here today to talk about issues with neighbors. So when we left off in the last segment, Chuck, I think we were talking with you about really the pros and cons of a condo owner acting as a director on the board. Is there something you'd like to wrap up with about that issue?
Yes, Susan, I just wanted to make sure that people understand that the liability, that a condo owner should not be afraid or feel threatened to serve on a condo board. They're protected by, their actions are protected by the board, and they're not going to be held individually liable. as long as they're operating within the board and its business. So they shouldn't be afraid, and that's how these condominium associations rely on the individual condo owners to serve on these boards. It's very important, and people should not be afraid to serve on them.
Okay, well, that's good to know, because many of us these days are, I think, living in a condominium setting. And actually, this brings me to the next topic that I wanted to talk to you about. Eric, I was wondering if you could help our viewers maybe walk us through the pros and cons and the details relating to renting. Yes. I know in this economy, surely you're seeing, I know I'm seeing in my practice, a great many people these days are actually choosing to rent.
Yes.
So let's maybe start out with a how-to. Can you walk us through that, the first steps?
Absolutely. You're right. With the mortgage foreclosure crisis that began in 2006, a lot of people are renting nowadays. And one of the things that's overlooked is documenting the condition of the property prior to taking possession. So after you've found an apartment or a rental that you like and can afford, you'll want to make sure that you take photographs of the unit before entering, document the condition of the unit, and be very detail-oriented with it, including noting carpet stains on the floor or paint chips on the wall. The idea is to document the unit so that you're protecting your security deposit, which people are very familiar with at the end of the term of the lease, but sometimes they forget about at the beginning.
Oh, that's interesting. Now, would you recommend that somebody actually include those, I'll call them defects, minor flaws, let's say? Should we actually include that in the lease or on a separate sheet of paper? Is it signed? Or?
Yes, what they should do is they should take notes on a document, share that information with the landlord, perhaps even include the landlord on the walkthrough. Ask the landlord to sign accepting receipt of that document, and then when you pay your security deposit, don't pay cash. Pay with a check, cashier's check, or money order, something that can be documented that you paid it.
I see, I see. What about with respect to leasing? You know, I wanted to talk a little bit more about neighbor issues, you know. How about that, Chuck? What if you're having an issue, you're having a difficult time with a neighbor? You're renting an apartment, you're living in an apartment complex, and you're having a tough time with a neighbor. Let's say it's a noise issue. How would you suggest that? What's the first step in approaching that?
Well, depending upon the circumstance, the first step is always to try to take care of it. You know, the best way to get out, to solve a problem is just usually the easiest way. Walk over and try to talk very reasonably. Anger doesn't work. Getting in somebody's face doesn't work. You know, go over and talk to your neighbor and say, hey, I got small kids here, or my husband's sick, or whatever, and you're making too much noise, your stereo's too loud. And that's how to solve it. If that doesn't work, you can always call a landlord. However, you know, depending on what time or how this is taking place, you may not be able to get in touch with the landlord right away, or he may not be able to do. He or she may not be able to do something. You can always call the police if it's a nuisance or something that really or
something dangerous.
Something dangerous that the neighbor, whoever, has just completely disregarded.
Right.
But it's all about good behavior, and that's the key. You know, living in close proximity with your neighbors, especially in a landlord.
Well, in this environment where we see more and more people renting, you know, I don't want to lose sight of the security deposit. I know you hit on that, Eric, but I think that's pretty important to most people these days. So let's say, first of all, what's the typical term lease? Is there a typical length of time?
Most people are probably familiar with a year lease, but because of all the uncertainty with the economy, landlords are more inclined, perhaps, to do short-term leases or 6-month leases. That's really just the result of an agreement with the landlord and the tenant. But certainly people can introduce those types of conversations prior to signing the lease, and really it's just an agreement between the parties to decide the term of the lease. But I think most landlords are probably most comfortable with a 1-year lease.
All right, so now we're at the conclusion of the lease. Let's say it's a 1-year lease term, and the tenant wants to move, wants to find somewhere else to live. What are the details surrounding getting that security deposit back?
Right. Well, the Illinois Security Deposit Act applies to landlords who lease 5 or more units in a particular building. For those landlords, they're required to send an itemized statement of damages alleged to the tenant within 30 days.
Within 30 days of the tenant leaving?
That's correct.
Okay.
and there's to set forth the actual cost or estimated cost of the repairs. If that itemized statement is not sent within 45 days, excuse me, the 30 days, the security deposit must be returned within 45 days.
Okay.
If a court were to find that a landlord ignored the act, the tenant could be entitled to double the amount of the security deposit, court costs, and attorney's fees. Now, again, that only applies to landlords who own or lease 5 or more units in a particular building. Right. If our viewers are in a unit where their landlord does not own 5 or more in that building, they will be subject to the terms of their lease or common law regarding return of their security deposit.
You know, and the simple thing, Susan, is that if you perceive that your landlord is going to be a problem in terms of returning the security deposit, you probably want to address it before you move out.
Like
so
how?
Invite the landlord over and say, look, when we started this, we had this agreed upon list of things that were a problem. I want you to look around now and tell me if you see that there are problems, and we'll talk about it. Then at least you know going in whether or not there's going to be some resistance to receiving your security deposit back. And it gives you a chance to do things like maybe forget to pay your last month's rent if you think the landlord is going to.
Right.
Well, and you bring up a good point. If you're proactive at the beginning, even the beginning of your lease or your when you begin renting, and you make a list of all the potential defects that are in there, it puts the landlord on notice that you're a responsible tenant. You're probably not going to be taken advantage of. They're pretty shrewd when it comes to that.
Yeah, yeah. So we okay. So to wrap up this segment, then there's no typical lease term, correct?
Correct.
That's a negotiated point.
That's correct.
Between the landlord and the tenant, right? If you're having difficulty with one of your neighbors, Chuck, you suggest first taking it to the neighbor, being polite and forthwith with this person, and see if you can resolve things that way. What if you can't? I mean, then what happens? A letter to the landlord? What's the next step?
Well, those are all options: a letter or a phone call to the landlord and say, hey, you're having a problem here with this particular tenant. And you do have a right as a renter. I mean, if there's something going on, you have a right to call the police. You have a right to, if the neighbor's being such a nuisance, or it's something, or they're doing a criminal act or something like that, if there's something ongoing at that particular location that maybe is in violation of the law, I mean, of course, call the police. Don't handle, if it gets to that point, don't handle it yourself. You've made the initial attempt to solve it by just going over and being polite in that. Never get in a confrontation with a neighbor.
Right.
Always come back and be very reasonable and rational about it.
Right, right. All right, well, we're about to wrap up this segment, and when we come back, what I'd like to do is talk a little bit more, John, about the distinctions between issues with neighbors in a renting context versus when you're a homeowner, and how it might differ and what the obligations of that renter or homeowner might be. So we're going to take one more break, and we'll be back very shortly with more legal action.
Abandoned and lost. From the dark, cold streets of the city to a cage in the local shelter, to heaven, your lap.
Hi, everybody. Welcome back to Legal Action. I'm attorney Susan O'Neill Alvarado, and this is our third and final segment, and we're talking today about issues relating to neighbors. So, Eric, I know we left off with you where we were talking about really the best way to handle a dispute with a neighbor if you're renting or if you live in an apartment. Right. And we talked about maybe going to the neighbor first, and then if that fails to check out let the landlord know. know. And John, I'd like now to compare and contrast that, if we could, to how you might handle that a little differently if you live in a house and you're a homeowner as compared to a renter. So tell us, what are your thoughts if you have a difficult situation with a neighbor and you're living in a neighborhood, in a single-family home?
Okay, well, the difficulties, they come in really two varieties. The one variety would be a behavior that a neighbor's doing that is disturbing your peace. And that's typically going to be a violation of a local ordinance, whether it's extreme noise or something like that. The other one, somewhat more interesting, at least to me, is that in our area, we have a lot of neighborhoods where people want to have some control over what the surroundings look like. And the neighborhoods are created with rules and regulations about, for example, whether you can erect a fence, and if you're allowed to erect a fence, how high and what type, whether it's chain link or wood, or whether you can have an above-ground pool or a shed or something like that. I think the key first is, if you're the homeowner who is concerned about what one of your neighbors is proposing, is make sure you're familiar with the rules and regulations. And if it turns out that a proposed change, for example, an unusual color paint, a lot of people might find that they believe that would adversely affect the value of their home. An above-ground pool is another example where some people object to them because they think it affects the value of their neighborhood. Once you know what the rules and regulations are, of course, you can call those to the attention of the person who proposes to make that change or to put up that thing that is in violation. The other thing you can do, if you find that the fence has been erected without permission or the pool's been put up without permission, is contact your homeowners association right away and insist that it require that the neighbor remove the offending structure. And they will get a court order that requires the neighbor to take it down. I've had a number of lawsuits involving fences, pools, sheds, and all that sort of thing, where they've been put up, and unfortunately the person who put it up without researching their right to do it has had to bear the cost not only of removing it, typically junking the fence or whatever, but also the cost of the fees to make that happen. So if you can communicate back and forth, you avoid much of that controversy.
That's the first best step, again, isn't it? Is communication between neighbors, you know? And Chuck, any thoughts from you on any difference between liability, personal liability or responsibility for accidents that might happen in your home versus in a rented dwelling?
Well, yes, of course there are. And remember, we were speaking before about ownership. When you own a single home residence, you have a responsibility to maintain that residence. Any conditions that you create on that residence as the owner, you're responsible for. If you create a defective condition or an unsafe condition, or you allow an unsafe condition to exist, if somebody's hurt, that's called proximate cause. If somebody's hurt and there are damages, you could be held responsible. This is why we have homeowners insurance that protects you. And also there are umbrella policies which are very inexpensive, which protect you from catastrophic injury. And believe me, in a home, while you shouldn't be afraid of that you're going to be sued or anything like that, you really have to take things seriously. You know, in a garage, for instance, you leave a garage door open. You have tools on the sides of the garage, shovels hanging or hooked up to nails. You'll see that in almost every garage. Some little kid runs in your garage, hits one of those shovels, it comes off, cracks him in the head. There's potential liability there. You know, you have a refrigerator in your garage. You leave your garage open. There's nobody in there. There's a beer in that refrigerator. There's alcohol in there. Those are situations that you created or known conditions that you left exist.
Right. I could talk about this all day. I think this is all just so interesting. What I'd like to do now is I'm wondering if I could ask each of you to give our viewers one last really important thought that you'd like to share with them about neighbor-related issues, homeowner-related issues. Eric, can we start with you? Is there something what's the one thing that you think is important for our viewers to remember?
Absolutely. It's important to set a budget when you are looking for a rental and to follow that budget to make sure that you can afford the space that you're renting. Your primary obligation under the lease is to pay rent.
Right.
So you want to make sure that you can afford the unit so you can satisfy the obligations of the rental agreement. The other thing I would add is that if you do get into a situation where you're experiencing a hardship, whether it be financial, medical, or otherwise, and you're unable to pay your rent, communicate with the landlord at your earliest convenience, because there are, the landlord would have a responsibility to mitigate some of their damages to try to find a replacement tenant. So if you communicate with the landlord, you can avoid disharmony and perhaps reduce your own exposure.
Very good point. Very good point. So many people tend to just go into, you know, they shut down and they don't want to do anything. Much better. Chuck, I would ask you the same question. From a liability standpoint, what's the one thing that you want to leave our viewers thinking about today?
Be a good neighbor. Communicate. You know, you see it in medical malpractice actions where there's a poor relationship between a patient and a doctor. There's much more of a chance to have litigation out of that, as opposed to a doctor who's open with his patients. Same thing with in a home.
Yeah.
You know, be responsible. Communicate with your neighbors. You don't have to like them. You don't have to be friends with them, but be responsible.
Right.
And that will solve 80, 90, 100% of your problems right there. And be reasonable.
Be a good neighbor.
Be a good neighbor.
Right. John, same question. You've seen a lot of these disputes over the course of your career. What do you think is one really important point you'd like to leave with our viewers today?
Well, Chuck hits it on the head with be a good neighbor, and I would say be an informed neighbor. So when you go into the transaction, when you buy the home, make sure that you're aware of what your rights and restrictions are.
How do you do that?
Well,
you read the guidelines.
Read the bylaws.
Right.
You go to the meetings. You ask people. As you see people around the neighborhood considering doing things that they want, you know, make sure you inquire as to whether they can.
Right.
And again, politely, don't be afraid to assert your rights once you're well informed, and simply call to the attention. Usually people who want to do something that's in violation of the rules, as we discussed a moment ago, aren't intending to break a rule. They're just unaware of it. And
That's
usually if they're made aware of it, they're willing to comply.
That's very true. And I would say the same thing. I would leave our viewers with exactly the same thought. This is an extremely interesting topic, and there's lots more to know about. If you're out there and you need some help with a neighbor-related issue, please feel free to call the DuPage County Bar Association Lawyer Referral Service. I'm Susan O'Neill Alvarado. Thank you to all of our panel members today, and thank you for joining us here on Legal Action.